Happy New Year, everybody. For my first video of 2023, I thought we'd talk about impending doom. Well, okay, that's still to be decided, but at the end of next month, February 21st, 2023, the United States Supreme Court is hearing arguments for a case called Gonzalez versus Google, which has major implications, not just for YouTube, actually, but for the entire internet. It's serious enough that, I'm low on the YouTube totem pole. I don't get invited to too many things these days, but I was even invited to a group call with YouTube employees, other creators, creator-adjacent business people to inform us of what this is and ask if we wanted to be part of something called an amicus brief, which will actually be used during arguments in the trial. So what is this case, Gonzalez versus Google, about, and why is it a big deal? I do want to give a disclaimer. I have no formal legal background. I'm sure that'll be obvious to people. So there probably will be better videos on this from other YouTubers who are actually lawyers. Keep that in mind. I'll still do my best to give the info necessary for this. So before we get into specifics of this case, we need to go back to something called Section 230 of the Communications Decency Act of 1996. This is where everyone tunes out. They're like, oh God, sections and numbers, and I didn't come here for this. What the frick, dude? Yeah, I know, but bear with me, because it is important. And like I said, the future of YouTube, at least in the form that we know it, does sort of hang in the balance here. So what is Section 230? Well, perhaps the most important text in it says, no provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider. What does that mean, simplified? Basically, it means that a website like YouTube or Facebook or Twitter or any site that hosts a ton of user-generated content isn't responsible as a website for the speech, the posts that the users post on the site. You can't blame YouTube because someone posts a terrible, awful video where they say horrible things. And this is very important because it's in contrast to, let's call them legacy media outlets. So think newspapers, TV news outlets. Those are considered publishers in that they are seen as expressly authorizing what is put forth, whether it's in the text in the articles or verbally said on the TV station. So let's think of something like slander or libel. Say a newspaper publishes an article that accuses someone out there of doing terrible things, but those terrible things aren't actually true. Well, that person can sue for libel, and the newspaper is responsible for having published that article. The difference here, which is protected by Section 230, is if someone goes on YouTube and says a bunch of slanderous things about someone, it's not YouTube's fault. You can sue the person who made that video, but you can't sue YouTube for hosting that piece of content. It's a very similar concept to the DMCA, which I think more people here are probably familiar with, in that what the DMCA is to copyrighted content, Section 230 is to speech. There is an important carve-out here that is different from the DMCA, though, and that states that no provider or user of an interactive computer service shall be held liable on account of any voluntary action taken in good faith to restrict access to or availability of material that the provider or users consider to be obscene, lewd, lascivious, filthy, excessively violent, harassing, or otherwise objectionable, whether or not such material is constitutionally protected. Okay, this just means that sites are allowed to actually try to execute good faith moderation on the content that's posted to them. And as opposed to the DMCA, where if YouTube tries to be hands-on at all and says, oh, you can't post this on our site, they're no longer indemnified. They have to be totally hands-off. With Section 230, YouTube can make efforts to moderate really, really bad content via the community guidelines without still being held as a publisher or not being protected by Section 230 any longer. So, in summary, Section 230 means people post vile things to YouTube. YouTube can try to moderate it, but at the end of the day, it's not YouTube's fault. So now we can get into Gonzalez versus Google. And despite the fact that YouTube and the internet's future hangs in the balance, it is an interesting question to ponder. And at the center of it is the algorithm, which we love to talk about here, right? The specific instance that actually brought about this case, ironically, I don't think I can even mention by name because this video will probably end up being suppressed, which means that the content moderation systems are probably working, I guess. So I have to kind of speak about it cryptically. So what's alleged here is that the YouTube algorithm served up radical, if you say yes, yes in Spanish and then reverse the words, radical that videos, which ended up contributing to the radicalization of viewers and then potentially led to them doing very bad things. And so the case asks whether Section 230 still protects websites when the algorithm is recommending content to viewers. So even though it's a very specific instance that brought about the case in the first place, it has wide-reaching implications, which is usually the case for things that get heard by the Supreme Court. Usually they are constitutional issues, and this is, in a way, a free speech issue. So will the court consider that a website, that YouTube recommending a piece of content to a viewer is an endorsement, is like a newspaper giving the okay to publish an article? Or will they see that almost all social media websites at this point, if not all of them, operate off of an algorithmic recommendation system, and to not give some sort of carve out there would more or less break the operations of all these websites? The scope of this is not even known, though. Like, where do you draw the line between what is considered algorithm and what is not? You might make the argument that videos recommended from channels you're not subscribed to on your homepage, maybe that's algorithm. Suggested videos to the side and bottom of the video you're watching, okay, maybe that's algorithm. But what about search results? If you're searching for something, you have to rank the content that shows up somehow. Is that also considered algorithm at that point? And I actually asked this in the call that I mentioned earlier, and I was told that there is precedent for Google search results to be protected. But again, even though this case is called Gonzalez versus Google, it is about YouTube. And so I'm sure that the defense will reference that, but I don't know that it's established precedent when it comes to YouTube search specifically. And so it's a very hard question to answer. What actually is the algorithm? This only applies, obviously, if the Supreme Court is thinking about ruling against Google here. But I guess that's why you're probably still here, is to find out what could actually happen if the court rules against Google on all counts. So God forbid, let's envision a worst case scenario here. We may not actually see immediate massive changes to YouTube. Because remember, this ruling wouldn't be, oh, the algorithm is now illegal, you can't make content recommendations. It would be that by making these content recommendations to viewers, you may now be held liable for what they've uploaded. So now if somebody goes and uploads a horrible, vile video that's a clear violation of the terms of service they agreed to when they made a Google account to be able to upload in the first place, but somebody sees it via an algorithmic means before it's taken down, and that person decides, I'm going to sue YouTube for this. And even if it's a frivolous lawsuit because it was a violation of the terms of service to begin with, YouTube has to defend that lawsuit. And defending lawsuits is very expensive. And if they start getting hit with enough of those, then it's going to be too expensive to keep the site operating in the way that it is. And at that point, they may be forced to start scaling back in places in order to avoid being hit by all of these lawsuits over and over, to the extent that the site can actually operate without being in jeopardy from them. So over time, if YouTube is hit with a deluge of these incoming lawsuits, does that mean that the only functions remaining are the ability to manually browse to a specific channel? That subscription feeds are the only thing that's active? Channels you've already hit the subscription button on, and therefore it's going to serve you content from them? Does search still work in the same way? Will that be carved out? Will it be exempt? But when you really think about it at the end of the day, as much as, I've complained about the algorithm here and there, usually that comes from like a selfish perspective, like, man, I wish it were recommending my content more. But what does YouTube actually look like? What do all of these websites look like without any form of algorithmic content recommendation? They don't look the same. Every social media platform these days operates to some scope on algorithmic recommendations. How do you find the people you're going to subscribe to in the first place without being recommended their content in some place? Search results, sure, but if I look in my YouTube analytics, over the course of my YouTube history, the majority of people who are here watching this, you discovered my content algorithmically. And without that, it's just going to crush potential for future growth for channels. And you have people who've obviously invested their livelihoods in building up a channel. You have people who recently got to the point where they can do it full time. Well, that's not viable anymore. They can't grow. There's no more algorithm to push their content and expose them to new viewers. I might be okay because I've been at it for so many years and I've been able to build up an existing audience that may still be able to find my videos through subscriptions, but it would still hurt dramatically. Still, at least half the people who watch every video of mine are not subscribed. They're finding that content somehow. Some may be searching for me directly, but I would bet a huge majority are being found in suggested videos, recommendations on the homepage. And without that, viewership plummets. If people have to go out of their way to try to discover new content, it's going to dramatically decrease the amount of interaction that content's going to see. So in the long term, you see massive loss of jobs. There are creators out there who may get tons and tons of views, but they also employ a ton of people. They have a lot of overhead. And all of a sudden, if you decrease that viewership even by 10, 20%, they're not able to meet their payroll. And the thing is, if YouTube falls, that's the final domino, right? They are the biggest, most well-capitalized entity to be able to try to defend against this and keep the site running without changes for the longest in the event that this case is ruled against them. Every other site at that point, smaller websites that are dependent on algorithmic recommendations, they're done. They're gone. They're not operating anymore. It's impossible. And so it's not just creators who get destroyed. There's also going to be employee job loss at tech social media companies across the board. And so while I'm not a constitutional scholar who can really determine how Section 230 applies to algorithmic recommendations, what I focused on in my contribution to the amicus brief was simply that these algorithmic recommendations, despite maybe having an occasional shortfall, have contributed tremendously to job growth and people being able to make a living and are necessary for these sites to be able to operate the way they do and are, I think, a net positive. Despite, again, everything that I've complained about in the past, I do believe that content recommendation systems are a net positive to websites and helping to allow creators to do what they do. Again, though, I do just want to remind that is an absolute worst case scenario. And in my 12, almost 13 years now on YouTube, I feel like we've seen enough legislative scares, SOPA, PIPA, the end of net neutrality that have come and passed and not ended up being nearly the apocalypse they were promised to be. So I also have hope that that will end up being the case here. But it's also good not to get complacent and be aware of things like this. And even though in this case there isn't quite as direct a way to participate, you can always call up your local representative and voice your concerns in the matter in the hope that maybe at some point there can be legislation that is actually passed in order to enforce that algorithmic content recommendations are concretely protected by Section 230, despite what may end up turning out from this case. If there are elements that are ruled against Google, there could always be legislation in the future that is passed in order to protect this sort of thing. So it's good to be aware of. I haven't seen too much coverage on this, interestingly enough, yet it was the first time that I was asked if I wanted to get on a call with YouTube employees and other creators to discuss it, which I did find interesting. Maybe as the trial gets closer, we'll start hearing more about it, but I still thought it was worth making the video, putting it out there, putting it on your radar in case it's of interest, and we'll just have to wait to see how it plays out. I do hope that algorithmic content recommendations will be able to remain. As much as I've complained, again, I do think it's necessary. So with that said, thanks for watching, and I'll see you next time.